5 seconds. The appellant number 1, that is Punjab State Electricity Board, is a statutory body constituted under Section 5 of the Electricity Supply Act 1948. The respondent number 1 was employed on work charged basis as a special foreman by the board as a fresh appointee. He worked in the same capacity from August 6, 1982 to January 5, 1984. With effect from January 6, 1984, he was appointed on regular basis. He retired from the service of the board with effect from July 31, 1990 on attaining the age of superannuation. The respondent number 1 thereafter moved a representation requesting the board to grant him pension and other retrial benefits after taking into account the entire service rendered by him on work charge basis under the state government. By an order dated January 25, 1991, the respondent number 1 was paid a sum of rupees 29,250, being the amount payable to him as death cum retirement gratuity. The relevant regulation framed by the board provides that an employee who has served for a minimum period of qualifying service of 10 years would be entitled to pension. The claim is board that the respondent number 1 had served the board for 7 years, 11 months and 25 days, including the work charged service in the board, and was therefore not qualified for grant of pension. The claim of the respondent number 1 was that service rendered by him in the state of Punjab as work charged employee should be counted for determining qualifying service for the purpose of pension. Therefore, he instituted CWP number 10911 of 1991 before the High Court of Punjab and Haryana, seeking inclusion of work charged service for the purpose of determining qualifying service. A division bench of the Punjab and Haryana High Court at Chandigarh, wide order dated January 28, 1992, allowed the writ petition of the respondent number 1 and directed the board to include work charged service rendered by the respondent number 1 with the state of Punjab for the purpose of determining qualifying service for grant of pension to him. It may be mentioned that the board had issued a finance circular number 2492 dated May 29, 1992, deciding to include the period of work charged service of an employee with the board for the purpose of grant of pensionary benefits as well as for counting the same period for determining qualifying service for grant of pension.